Hello, everyone, and welcome to JAMCOPY's celebration of World Intellectual Property Day 2024. Today is a seminar for visual artists, particularly for those who make a living from art. And that's why we have named our seminar Art and My Bread and Butter, because we're going to be looking at specific practical information to help those who are in the business of visual art how to protect their intellectual property and how to maximize their intellectual property in their business. So to start things off, I'm going to be looking at the backdrop, the legal framework within which we work, which is intellectual property, in particular copyright and how that is protected in Jamaica. So just to say, perhaps you're already aware, when we talk about intellectual property, we're talking about something that you own, something that has value, and it's really the fruits of your mind or the creations of your mind. So whether it's artistic or musical or dramatic or it's an invention, you have rights under the law to your original creations and how you would use them and to be able to earn a living from their exploitation. And we have three big areas of intellectual property: industrial property, under which we have industrial design, patents, trademarks, and geographical indications. Then we have copyright and related rights, which I'm going to be speaking about shortly. And then there is another area called traditional knowledge that will look at beliefs or music or knowledge about medicinal plants or other sorts of heritage, elements of heritage. For example, the practices of the Maroons in Jamaica or the Rastafarian community that we would be protecting under traditional knowledge. And there is an area that is called an allied rights, that they're not quite intellectual property, but they have protection that is similar to intellectual property in terms of ownership and being able to prevent others from using it without your permission. And that would be trade secrets and image rights, image having to do with your profile or particular poses that you're well known for. You can protect these as image rights. Now, the government office that is responsible for administering the intellectual property laws in Jamaica is JIPO, the Jamaican Intellectual Property Office. And you would go to JIPO to register your industrial design, your patents, your trademarks, and your geographical indications. JAMCOPY, we are a private organization, and we specifically work with authors and publishers of literary and artistic works. Now, as a visual artist, you may want to think about protecting your trademark, registering your trademark. That's the logo or the tagline that is part of your branding that distinguishes you from other visual artists offering the same services on the market. You can register your trademark, and that would be through JIPO. And also, if you are an artist who creates designs for ornamental or everyday products, so whether it is jewelry or fashion clothing or chairs or a table, but you've created some sort of new fashionable, original aesthetic design to these everyday products, you could also protect your work as an industrial design. And so you would want to call JIPO to get more information. But this is the big picture of intellectual property, the different heads of intellectual property, and let's zero in on copyright. So we have a Copyright Act of Jamaica, and what it says is that original works that are original to you, meaning that you've not copied somebody else's work. It doesn't mean that it has never ever existed before. It's just that it is your original creation. You have exercised thought and choice in putting together the colors, or if you are writing a poem, the words, or you're choreographing the dance, the moves. It is original to you. And what are the works that are protected under the copyright law of Jamaica? Literary, meaning lyrics of a song or a book or poetry or a newspaper, what's written in newspapers or journals, articles for journals. Then artistic, meaning photographs or architectural designs or illustrations. Dramatic has to do with, well, yes, a play, but also the choreography of a dance, if it is communicating a storyline. Music, it has to do with musical compositions. Then sound recordings is the recording of the sound, like a CD. Broadcasts, it's the programs that a radio or a television station would broadcast. And cable programs would be the content of programs put together by a cable operator. And so copyright protects the original expression under these types of expressions. Now, to know that copyright does not extend to ideas or concepts or processes, principles, procedures, systems, or discoveries, but it's really the expression of the idea that is protected. Also, these other ideas of principles or procedures, they might be protected under other types of intellectual property, for example, a patent. So specifically on artistic, what does the Copyright Act say an artistic work is? We mean a graphic work, so it has some sort of image to it. There's a photograph or a sculpture or collage. And the act is not looking as to whether it's a great quality or not quality. It's not judging quality. It's really saying if you have created something original to you that falls under this type of expression. A building or a model of a building would also be considered an artistic work, or a painting, a drawing, a diagram, an engraving, an etching, a woodcut, or similar work. And the author of the work, that is the person who would enjoy this protection under the law, is the person who creates it. The person who is the artist or the illustrator, or the person taking the photograph, the photographer. Now, in terms of what rights you have under copyright, automatic, it's the protection. It's automatic. You don't have to register it anywhere. You don't have to go to JAMCOPY with your painting or illustration or your story. It is automatic once it exists in a written or recorded form. So the idea for the photograph is not in your head. You've actually taken the picture and it's on your phone, or you have developed it and you have the actual physical picture, or you've actually made the sculpture, or you've actually drawn the illustration. Once it's in a tangible recorded form, then you have copyright protection. You should also make sure that you have written your name, the date on which you've created the work, and the international symbol for copyright, which is the letter C inside of the closed circle. Now, that doesn't give you copyright, and not having those elements on the recorded work doesn't mean you don't have copyright, but saying your name, the date, and the letter C inside of the closed circle communicates to anyone who is coming into contact with that illustration or painting that that name is the person who is claiming authorship of that work. That person is claiming that they made the work on that date, and they're claiming copyright protection. So it's a statement to the world. Now, how do you prove that you are the author, you might ask? Well, there are several ways. Certainly, you could do something called self-registration. I'm sure you've heard it. Maybe it's called poor man's copyright. You've heard of it that way. Well, it's really you taking a copy of the work, not the only copy, a copy of the work, putting it in an envelope, sealing the envelope, going to the post office, and putting your name and address on the envelope and mailing it to yourself through registered mail. And when that envelope comes back to you, you would attach the slip from the post office, the registration payment slip, to the envelope, keep it sealed and keep it somewhere safe, so that if ever you had to go to court because somebody had the exact same work like you, and they claimed that they created that work and it was original to them, and you brought an legal action for copyright infringement, you would use that sealed envelope and it would be open in court as part of your evidence to support your claim that you are in fact the author of this work. Now, let's just be aware that somebody else could come up with the idea of that same painting or illustration that you made. The question is whether they saw yours and copied it exactly and then claim that it is theirs when it really isn't, or whether you just happen to have had, both of you, a similar idea, but you've had your original expression and they have had their original expression. You could also use a voluntary registration system available through JIPO, that's the government office, where you would give them a digital copy of your work. And they would issue a certificate to say that on such and such a day, you deposited a digital copy of the work under this name. Now, they're not giving you copyright. You already had copyright. This is just simply some sort of statement that you claim to be the author of work and it was deposited with an independent entity other than yourself on such and such a date. The law says that any published work in Jamaica is required to be deposited with the National Library of Jamaica, as there's an act called the Legal Deposit Act, and it requires published works to be deposited. It usually is musical works and literary works. You could check whether your particular creation would fall under Act, but there is a requirement. And this is really to build up our archive of heritage works created. This is really to build up our archive and our heritage of works created by Jamaicans. And so if you have created a work that is required under the Legal Deposits Act, do contact the National Library of Jamaica. And then if your work is available for sale to the public, you can affiliate with JAMCOPY. And I'll say a little bit more about what we do and how we support authors and publishers later on in this presentation. The next step then is to commercialize your work. Now, it's up to you. You don't have to put your work on the market. It's up to you. But if you do put your work on the market, you are exercising your copyright and you can earn from the commercialization of your work. And you certainly have rights under the law to take legal action if somebody is using your work without your permission. And using your work without permission is called infringement. You can sue the person, which is a private action, or if somebody has made copies, mass numbers of copies, that it would amount to piracy, the police can be brought in and the state would take legal action because it would be a criminal action, those acts of piracy. So what rights do you have under the law? There are two categories, economic rights and moral rights. The economic rights, as the word would suggest, are activities that you can use and earn an income from doing those activities. They are to financially benefit you. And because you have exclusive rights over your work, nobody's supposed to be doing any of these activities without your permission. Doing any of these activities without your permission is called infringement. And what are the activities? You have the exclusive rights to copy your work, that is to make a second or a third or however many copies of the work, to issue those copies to work, whether for sale or to give away freely, that's up to you. To have the work performed in public, think about a concert or a poetry reading. To have the work broadcast, whether on Reddit or television or included in a cable program. To have the work adapted, so think of turning a photograph into a postcard or using an illustration on a t-shirt. That's using the work in a different form than which you originally created it in. That's an adaptation. And for the work to be communicated to the public, so made available on the internet. So if you put up a blog or if you have a website with your paintings, making it available to the public, all of these activities are exclusively held by the copyright owner, and anyone wanting to do any of these activities would need their permission. In terms of moral rights, the author of the work has the rights to be identified as the author. So if your painting or photograph is up, your name should be attached to that work and not anybody else's, because you have the right of paternity. You also have the right of integrity to object to any kind of derogatory treatment of your work. If your artwork is being used in a way that you consider offensive and that would be demeaning to your reputation, or if your sculpture is being placed in a location that you would not have given authorization for, or you consider it demeaning to your reputation, you can exercise your moral rights to object. You also have the right to not be attributed as the author. If somebody has written a poem and they've put your name because they want to take advantage of your celebrity status or your fame, but it's not your poem, you didn't write it, you have legal rights to object to your name being used. That is you being falsely attributed. So these are the rights under the law that the copyright owner, the author of a work, holds. Now, when I talk about copyright owner and author, am I meaning the same thing? Let me explain. The author is the person who created the works, but because your copyright is an asset and what you've created as property, it can be sold, it can be licensed, it can be bought. You can give the rights, the economic rights, to somebody else. So the person who has bought your works, or you have licensed, you're giving them permission to use your work for a particular period of time, they would be enjoying the economic rights. They would be enjoying the financial benefit of commercializing the works. You are the author, but you're no longer the owner if you have assigned or sold the works or licensed the works to someone else. You would retain your moral rights, the right to be identified as the author, the right to object to any derogatory treatment, and the right not to be falsely attributed. You would always retain your moral rights. They can never be waived. But if you have sold your copyright, you are selling the economic rights. Someone else will be enjoying the financial benefits of using that copyright. No, but it also means that if you license your work to different persons for different uses in different locations, you could have multiple income streams. So if you, for example, you give somebody the right to use your artwork on some textbooks in Costa Rica, or maybe use it for t-shirts in Botswana, or maybe you're allowing them to use the photographs for a banner in the UK, you could restrict the use of the work to those geographical locations for a period of time, 2, 3 years, 5 years, up to you to decide. And at the end of the time period, the rights return to you completely. But the person in Costa Rica, the person in England, in the UK, and the person in Botswana cannot use your artwork other than how you have given them permission to do it. And they can't go and do what the people in the UK or Costa Rica or Botswana do. They can't switch around the use of the works. But you would be earning financially from the use of your works in these different areas, in those different geographical areas. So this is just an example. It's not necessarily how you would use it, but I'm just giving you an example of how you can divide the rights, divisibility of the rights, in order to enjoy multiple income streams by use and geography and duration of the use. Now, it's very important for persons who buy artwork to understand, even though you may have bought the canvas that is framed and you own that physical item, you don't own the copyright. You don't own the intellectual property in that painting. You may own the physical representation and you can sell that physical representation, but you don't own the idea that has been expressed in that painting that is on the canvas. Hope that is clear. Now, let's just go on to something that's called fair dealing. Now, whilst the Copyright Act gives the author and the owner of the work exclusive rights for a period of time, the law also allows the general public to use works in a very limited way and without having to get permission or to pay a royalty. It's called royalty-free and permission-free uses, and we call it fair dealing, which means that you have to deal with the work fairly. And here are the areas in which you can fair deal with the work for your research or private study purposes. If you're critiquing, maybe it's a new artwork or a book of photography. If you're reporting current events, but you can't be using the photographs for reporting current events, though you'd have to get permission. And certain copying by libraries. If I go to the library and I have to make a copy for my research paper, I would be allowed to do so without having to get permission or pay a royalty. What is fair depends on the nature of the work, the extent of how much you would be dealing with, and the purpose and the character of the use, but also the effect on the commercial value of the work. Which means, though, if you're going to be using a work in mass quantities, that is going to affect the commercial value of the work. And therefore, you would need to get licensed, you would need to get permission from the author or the owner of the work. But if it is for these limited areas, you can deal fairly with a work. There are also other exceptions. If you're copying a work for the setting of exams, if you cite the work, you must give sufficient acknowledgement. Students, you know, in your references or your bibliography, you must say where you got the information from, or if you're quoting from somebody, to use the quotation marks. Buildings and sculptures that are in a public place, you can take a picture in front of the sculpture or the building, or make a film of it without having to get permission or pay royalties. And if the author, the artist themselves, makes a subsequent work of their artistic work, they're free to do so. Maybe they have a particular style or pattern, they can replicate it, but that subsequent work must not repeat the main design of the earlier work. Now, how long does copyright last? It lasts as long as you're alive. That's the author, the creator. plus 95 years after you've died, which means that your work can be used and can be earning an income even after you've passed. So it's very important for you to include in your will all of your assets, which includes your intellectual property, so that your children or your grandchildren or whoever you want to bequeath your rights to, your estate, they would be able to enjoy the benefit of your copyright for 95 years after you've passed. But it's important to put it in the will and state it very clearly in the will. Now, I said I would tell you a little bit more about JAMCOPY and what we do. We are one of 3 collective management organizations in Jamaica. We're private companies, we're not government. And by collective management, we mean that we are working on behalf of the collective, the grouping of artists, writers, musicians, performers. We are acting on their behalf in managing their copyright. Now, remember I said that copyright is a private right. You have the right to give permission to somebody to use your works. But we recognize that it is going to be very difficult, very expensive and time consuming for you to track down everybody using your work, or for everybody to try and find you wherever they are in the world. So these collective management organizations, or CMOs, we exist around the world to help authors and publishers manage the use of their works. There are 3 of us in Jamaica. JAMCOPY, we focus on text and image-based works, or literary and artistic works. And JCAP and JAMS, they are focusing on music. JCAP represents authors and publishers and composers of musical works, and JAMS represents record producers and performers. But we do the similar work of collectively managing, assisting the creators of these works in the use of their works by the general public. Now, JAMCOPY, when we are representing the authors and publishers of works, we are representing them for the secondary uses of their work. And by secondary, I mean the copying or the photocopying of their work. So they would have the rights to put their book or their book of photography or their articles in the newspaper on the market. But what if somebody takes the newspaper? What if somebody takes the book and makes photocopies of a couple of pages out of it? A teacher might be making a copy of some of the pages out of a book for her classwork, for her class time. What if an institution makes some copies for the course pack? They would need to get permission, because it's in mass quantities that it's being made. They would need to get permission from the owner of the work, or somebody in Australia or in the UK or in South Africa or in Ghana might want to make use of a Jamaican work. How do they get in touch with the owner of the work in order to get permission? Well, this can be facilitated through JAMCOPY, where we would represent the author and publisher, and we would grant the license to the school or the educational institution, or the entity in Ghana can go through their CMO in Ghana, who would have a relationship with JAMCOPY in Jamaica, and we would make the exchange of rights through that medium. And when we talk about copy, we're talking about a literary copy, a literal copy, a literal copy, a reproduction of the work, 3-dimension, 2-dimension. It is a literal copy of the work. And when we talk about copy, we mean a copy is a copy. So in long time days, you would have had literally making the copy by hand, but now we have photocopiers, now we have digital, but the principle is still the same. If you have printed something from offline, if you have digitized or scanned something, the hard copy, if you have sent email to email or put it up on an intranet, you have made a copy and you need permission in order to make that copy. Don't think because it is on the internet and you can easily get on the internet that you can just download freely and use the artwork, whatever you want. No, you need to check on that website if there are restrictions or indications of how you're to use the work. Check the privacy notice, check the terms of use, check the copyright disclaimer, because if you use the work and you don't have permission, you are infringing and legal action could be taken against you. And so if you want to make use of the work other than research and private purposes, you need to get a license. You could check JAMCOPY if it is text and literary works. If it's music, check JCAP or JAMS, or reach out to the owner of the work through their website if they don't fall under one of those three areas. And so, as we're saying, that the CMO is the go-between the user of the work and the owner of the work. We're like a bridge. And by having a license, consider it as insurance. Consider it as some sort of protection against you being charged for infringement, because the license is permission to use the work. There are terms and conditions in the license as to how much you can copy or cannot copy, and you would have to abide by the license. And if you need to copy more than what is in the license, still ask JAMCOPY or JCAP or JAMS. If you need to use more than what's in the license, they would be able to interface with the owner of the work to get that permission for you. So this little circle shows you the cycle of activity for the collective management organization. We get mandates from the rights holders. We get their authorization to act on their behalf. We have bilateral agreements, which is international contracts with our equivalents in the other territories across the world. We negotiate with the user, like an educational institution or the government or a business. We then give them a license for the copying that they are making. And then we collect the fees, the license fees, and then we pay that as royalties to our owners who have affiliated, who have joined with JAMCOPY. And we encourage the respect for copyright, like what we're doing today, celebrating Intellectual Property Day, but also empowering our visual artists and creators as to how to protect their work and how to maximize their copyright. You can visit our website, jamcopy.com, for more information on what we do, as well as copyright, and to see who are the licensees in Jamaica. And here they are, so many educational institutions at the tertiary level, but also at the primary and secondary level. And they have a license from us to make legal copies of extracts of works in their work of teaching and learning. And finally, I'm going to close off with a word about Creative Commons. Perhaps you have heard about Creative Commons, where creators, authors, and publishers of works, owners of copyright, have decided that we want to share our work freely with others. We are going to allow them to use our works in certain ways without having to get permission, without having to pay a royalty. They still have copyright, but they have voluntarily decided not to exercise exclusive control over their works. You would go onto the Creative Commons website to get more information. And if you go to a website or a blog and you see them have the CC signed, they will indicate what you can do, whether you can use the work by simply saying, Philippa Davies was the one who made this artwork. That's all they're asking for, attribution. Or they're allowing you to share the work with others without having to get permission, or they're allowing you to use the work, but without commercializing. If you commercialize it, you would have to get permission from them. Or you can use the work, but you can't create a derivative. You can't adapt it. You can use the artwork as is, but you can't turn it into a postcard, can't turn it into a t-shirt, can't turn it into a poster or a flyer. So check whether the persons have indicated it. You can freely use it with a Creative Commons license, but how you can or cannot use it. And this is up to you as a creator, how you want to make your work available to the public. Let me just say, though, that if you would want to join JAMCOPY for us to help you manage your secondary rights, you can't both give free permission to persons to use the work and also ask JAMCOPY to manage your rights. That would be in conflict. So you would need to decide which works you want to allow persons to have free access to use and which works you would want to retain full control over. And those would be the works that JAMCOPY would help you in managing your rights. So I hope this has been helpful to give you a background in understanding framework of intellectual property, but also copyright. And so if you have any questions, feel free to send them to us, info@jamcopy.com. But stay tuned to some more of the presentations from Art Amid Bread and Butter.